Thanks very much. It's a terrific thing to see real human beings again, to see people leap out of the two dimensions like the Purple Rose of Cairo. And it's a tremendous privilege to be here. I'm Michael Spence. I am the President and Provost of UCL. I also have the privilege of being a legal academic, and so I'm particularly looking forward to this evening's lecture. I should start, I have to say, and for those of you from other universities, I'm sorry for this, simply by congratulating the Faculty of Law on our extraordinary research assessment exercise results. To be ranked best in the country for research power would be great. To be ranked best in the country for research quality would be good. To be ranked best in the country for research impact would be terrific. But all three, the trifecta, is quite extraordinary. And it's quite extraordinary for a faculty that I watched coming in the middle of the pandemic take teaching incredibly seriously. This is not a place that cares about research and leaves students alone. This is a place that teaches and teaches hard, that cares about the student experience, that is deeply committed to bringing on the next generation. And it's a place too that does not only well in relation to research assessment exercises, but also in scores for student satisfaction and the rest. The UCL Law faculty is a really remarkable place. Well, of course, UCL is a really remarkable place in all sorts of ways, and one that it's terrific to be able to welcome Karon along with all of you this evening to think about this topic that for us is particularly apposite. Because, of course, a part of the founding narrative of UCL, a part of our founding story, deep in our DNA, the Bentham thing, if you like, is this concept of inclusion. This notion that we should be a place that wasn't necessary, that was open to others for whom the doors of other universities were at the time closed, a place free of religious and property tests. What an extraordinary thing. And yet, of course, we were a place open so long as you weren't a woman and so long as you came from a particular social class. Well, we did a little bit better in our history on the gender issue. We claim proudly to be the first university to admit women on an equal basis with men. But social class, well, that's always been a little more complex for UCL. So 30% of our undergraduates currently are educated in independent schools, a disproportionate amount. And from next year, we'll be taking 25% of our undergraduates with contextual offers, thinking about what it means to be true to our tradition of being a genuinely open university. But as we do that, we know also that we are sending those young people into an environment in which, although it's not legally recognised, discrimination on the basis of class background is alive and well. And indeed, we've been talking to the City of London about the work that they're doing with the government on discrimination in the higher ranks of the finance industries against people in particular with working class backgrounds. And that intersectionality between class and the protected characteristics, that intersectionality is a great unspoken in our community. And so to have this evening a lecture on that topic, as UCL, as one of our strategic commitments, begins to think about what it means to harvest the intellectual resources of the university as a whole, to address injustice not only in our community but in our own life as an institution. To have that be the first Bentham lecture back, the 72nd Bentham lecture, seems particularly apposite. And so it is a very great privilege on behalf of UCL to welcome you all here this evening to this 72nd Bentham lecture. Thank you.
Good evening. I'm Stephen Vaughan. I'm the Vice Dean of the faculty. Let me offer my own very warm welcome to this evening's address. So the topic of tonight's lecture is a matter very close to my own heart, both personally and professionally. As a scholar, part of my research is about diversity, or the lack thereof, in the legal profession. And I come from a very lovely, very ordinary working class family in Liverpool, and went to a very lovely, very ordinary working class state school. And when I was younger, I had a very strong Scouse accent. And over the years, that accent has become something different. And the main reason for that is that on my very first day at law school, not at UCL Laws, I hasten to add, someone said to me, "I didn't think we let people with accents like yours into a place like this." That was very hard to hear. Skip forward, and over the years, there were countless instances of me using the wrong cutlery, me wearing the wrong suits, often from C&A, now from Marks and Spencer's, me liking the wrong sort of music, so Whitney Houston instead of Radio 4, and me trying to mellow and round out my accent into the sort of mishmash that you hear this evening. So class and its consequences have been a very constant companion in my professional life. Now, as a faculty, we're trying to do better. So we have followed UCL's lead and reduced our contextual offers down to 3 Bs. We've also taken the decision as a dean's team to double the number of widening participation home students who will arrive in September 2022, and perhaps more importantly, to offer them a whole suite of support measures led by Karon Scott, who's here with us this evening. We've also put a whole range of resources into a program called Target Laws, which will see us go out into a whole range of schools and work with students from lower class backgrounds into studying law at university. They're very small steps, and I don't share them with you out of any sense of a particular accomplishment or because I'm particularly proud about what we're doing, but to be transparent, so that you can come back in the years to come and hold me and the faculty to account to see if we've done better, to see if we look better. So as I say, the topic for this evening is close to my heart. I'm also a very large fan of our speaker. So Karon Monaghan QC is a barrister at Matrix Chambers. She was called to the bar in 1989 and took silk in 2008. I imagine Karon will speak perhaps about her path to the bar in her talk. Oh. But let's just say it was an atypical path. And from that atypical path...
Whitney Houston was along the way.
A Whitney Houston path, no better path. Karon is now one of the most expert, most recognised equality and human rights lawyers in the country. She has a very broad, largely claimant-led practice of the bar, encompassing public law, employment law, and civil action. So I spent some time today on Karon's web profile, and I make it, but I may be wrong, at least 14 separate appearances in the Supreme Court, and in a slew of cases that will be very familiar to us. So Unison, access to justice and the rule of law, Pimlico Plumbers on the definition of workers, bedroom tax case, and so on. Karon has also appeared frequently in the Court of Appeal and in Hong Kong, in the Court of Appeal there and the Court of Final Appeal. More broadly, she's acted for a range of individuals, regulatory and other bodies, in a whole slew of public inquiries, including the Infected Blood Inquiry and the Grenfell Tower Inquiry. Away from court, Karon is also widely published. I saw papers in the Industrial Law Review, the Journal of Law and Policy, European Human Rights Law Review, Judicial Review, chapters in a range of distinguished edited collections, and as the author of Monaghan on Equality Law and Blackstone's Guide on Discrimination Law. Given all of these successes, Karon is also repeatedly and rightly decorated. She was Liberty's Human Rights Lawyer of the Year Award in 2010, Employment Silk of the Year in 2017, both in the Chambers and Partners Bar Awards and the Legal 500 Awards, in the Hot 100 list for 2018, in the Lawyer, and the 2019 Outstanding Achievement of the Year Award recipient at the Modern Law Awards. In the directories, Karon is referred to, and I quote, as a leading light, a force of nature, with great vision and great instincts. I've had the pleasure of hearing Karon speak on a number of previous occasions. All of those accolades are true. We are very fortunate to have her here this evening as our speaker. I imagine that she won't pull any punches. I think we will leave this evening better informed, better educated, but perhaps also feeling challenged and slightly uncomfortable. And I think they're good hallmarks of any lecture on class. Karon, over to you.
Thank you ever so much. Thank you ever so much. That was very, very, very kind of you. I wasn't going to say anything about myself, but since you mentioned it, accent, I don't think my accent's changed, but that's, I don't know, for a number of reasons. But one of the first things that was said to me when I came to the bar was, "Is your accent a problem?" And until then, I didn't know I had an accent. I mean, I know it sounds bizarre, but why would you? You live in a particular community, you don't recognise it. But anyway, that's not what I'm going to speak about. That was not on my list. So what I propose to speak about is, firstly, the meaning of class. What does class mean? And the characteristics that do define it, or might define it, and whether the law is apt to deal with class-based inequalities, and if so, how? I'll finish by briefly considering whether we have a judiciary that we could safely rely upon to determine claims of class-based discrimination. I won't spend too long on that, given the audience we have, but I will ask that question. So as to the meaning of class, first of all, and that must be the starting point, obviously, if we're going to consider whether the law should address class by itself as a particular characteristic. By and large, we know what the protected characteristics under the Equality Act mean. They're either self-evident, like age, civil partnership, marriage, or where they require some further definition, provision is made under the Act to set out precisely what Parliament meant by either of those, or whatever those expressions. That's not to say that their meanings aren't controversial. Everybody will be aware now of the discussions around sex and gender reassignment and what those concepts mean. But there are other protected characteristics where the meaning to be afforded them is controversial and there's still arguments to be made. But in the main, the meanings to be afforded the protected characteristics under the Equality Act are tolerably clear. Class, of course, is not a protected characteristic under the Act, and if it were, it would require further definition, and this is because the meaning of class, or what is meant by the label class, is not self-evident. I'm not a political philosopher, of course, but I think the simple or perhaps very complex concept of class that we see in Marxist notions of class, comprising on the one hand the owners of the means of production and on the other the proletariat or the working class, doesn't sit comfortably with modern conceptions of class that have developed within a very different social and economic environment, particularly post the Second World War. So the concept of class, I think now, or at least membership of a particular class, and I'm here focusing on the working class, even if related to labour market status, is not inextricably linked to it, in my view. And that means that if we're looking at protecting against class inequality, then we need to be looking at characteristics that extend beyond the labour market and beyond the working class's relation to capital. It's said by Friedman and Lorison that occupation is the single piece of information that by itself, on its own, tells us most about the probable socio-economic conditions that characterised a person's background. But that's not to say, even if a partial proxy for class, that's not to say that it wouldn't be too reductive to treat class as only relating to status in the labour market. And nor does class necessarily denote poverty. Of course, there is a close correlation between being working class and being poor or economically disadvantaged, but there isn't a necessary correspondence between those two characteristics. And nor is there a necessary correspondence between broader social advantage or disadvantage and being working class, in particular in relation to particular individuals. So by that I mean one can be an individual that is presently not suffering socio-economic disadvantage, but nevertheless might be a member of and self-identify as a member of the working class. So there's more to it than simply place in the labour market or indeed socio economic status, or particularly economic status, it's been argued that how we should determine class is by reference to what's described as capital, various forms of capital, parents' stock in particular. So economic capital, wealth and income, this is looking at one's parents, cultural capital, educational credentials, and the possession of legitimate knowledge, or knowledge that is legitimised by the middle classes, skills and tastes, not Whitney Houston, and social capital, so that's valuable social connections, friends, and so on. And very importantly for this lecture too, we tend to inherit those credentials. And the smaller the capital so defined, the greater the disadvantage. I'll come back to inheriting those credentials in a moment. In addition to cultural capital, there is culture, and that matters. Class status denotes something in addition to economic and occupational status. We remove poverty, we remove position in the labour market. There's nevertheless something else, and that's the cultural space that we occupy. The great Stuart Hall defined culture as referring to that level at which social groups develop distinct patterns of life and give expressive form to their social and material life experience. Culture is the way, the forms in which groups handle the raw materials of their social and material existence. And that material existence includes economic security, occupational status, but also environmental circumstances, that is, broader social circumstances, as well as environmental in the way it's ordinarily used. And working class people have handled those raw materials by creating distinct patterns of life and expressive forms, or culture. In addition to a distinctive way of life, culture for these purposes includes the meanings, values, and ideas embedded in institutions, embodied in institutions, I'll come back to institutions, in social relations, and in the systems of belief, customs, and so on. So given that what we're talking about here are raw materials, the raw materials of social and material existence of the working class, culture is necessarily particular, relates in particular to the working class. It's distinguishable from that of other classes. This doesn't mean that that working class culture is homogenous, doesn't mean there aren't subgroups, subclasses, or indeed that for some members of the working class, the raw materials that Stuart Hall referred to have particular features which take on greater prominence and produce distinct social or cultural norms. So as again Stuart Hall put it, race is the modality in which class is lived. It is also the medium in which class relations are experienced. And the same is true of sex, of course. Just as to working class, or being working class as a cultural experience, something beyond mere labour, research demonstrates that some people are more willing to identify as being working class as compared to others. Some research, perhaps actually predictably, but some research indicates that older white men are more readily inclined to identify, more confident about identifying as working class. That may be to do with stigma and how certain parts of the working class, certain members of the working class are particularly stigmatised, and that includes women. But perhaps most people, when presented with class or culture, take pride in it in one way or another. And although that may be expressed differently, as I've described, in relation to race and sex, nevertheless underpinning it is a pride in origins and the experience of class. As I say, expressed differently perhaps. So if one looks at the intersection between race and class, black people or people from minority ethnic groups will often see class through a different prism. They'll take pride in a commitment to community, local values of solidarity and camaraderie, and that's seen as a particular part of identity and valued as such. So there isn't a single cohesive class consciousness, but nevertheless, even with those distinct experiences that I've touched upon, the working class as a whole can be viewed or seen as a singular whole with diverse groups within it, race, for example, sex, and so on. As the Runnymede Trust has identified, these groups do not live completely different lives. They refer to the 4 Ps that bring together the working class as a whole, and those 4 Ps are precariousness, power, place, and prejudice. So not an homogenous group, but there are key elements to membership of that group which ensure that one can identify the working class as a single whole. So class exists, and notwithstanding the diversity of its members, it is recognisable by a collection of characteristics. I will come to the law, I promise you. Those include economic and material disadvantage, the shared experience of indifference and neglect by public authorities, and culture, albeit that culture may differ in some respects. The question then, for the purposes of the law, is whether or not class is intrinsic or immutable. Can one ascend or climb out of one's class, one's working class status, despite its correlation with poverty and labour, social hierarchy? It is not a phenomena, or forgive me, it is a phenomena, removing all those characteristics, so taking away one's place in the labour hierarchy, taking away poverty, class is still a phenomena and there is a permanence about it. So it might be said that there is a degree to which class is intrinsic, so far as our own personalities are concerned, and immutable. Come back to that in one moment, but that's obviously important for determining whether it's appropriate for legal protection and considering whether or not it's analogous to those characteristics that are already protected by law, like sex, race, and so on, that nobody would dispute as immutable or intrinsic to one's human personality. So there's a permanence about class membership and immutability about it, even though it's defined by reference to external characteristics. And we know that there is immutability or permanence about class. Firstly, as a matter of fact, social mobility is illusory, largely. Very difficult for working class people to move up the social hierarchy, indeed. There are more working class people or people of working class origin within the managerial and professional classes. That is by way of number, but in terms of proportion, the position is the same. We've just seen a growth in managerial and professional classes, but in terms of the proportion of working class, those of working class origin within the professions and managerial classes, that hasn't improved at all. As well, cultural capital, that is that which comes from working class origins, or indeed middle class origins, remains important even when one moves up the labour ladder and the social hierarchy. So working class people find it more difficult to establish merit. They don't have connections. They don't engage with dominant ideas about what merit means, about how people ought to perform in an expressive sense, not just in terms of performing or achieving work, how they should perform at work in an institution or environment that's dominated by middle-class people, and they don't often feel they fit in. I'll come back to the concept of fitting in when I come to the law, which I will do in one single moment, but I do need to contextualise it. But what it does mean, just to wrap up, if I may, in terms of the meaning of class, the effects of class origin are pervasive and long-lasting. There is a degree of immutability or permanence about them, and very often, however one tries and however one even enters the professional and managerial classes, one can't climb out of it. So as to the law, class, as I've said, is not a protected characteristic. In the main, class disadvantage is dealt with through labour law and welfare law and equality law. I'll say something about equality law, and that's because the experience of inequality associated with class very commonly and disproportionately intersects with other protected characteristics like race, sex and disability. So there is a relationship between those two things. I'll come back to welfare benefits. But first of all, the Equality Act and intersectionality. The Equality Act covers a broad range of characteristics. We've already identified some of them: sex, race, disability, sexual orientation, gender reassignment, age, probably missed some. But looking at sex, race and disability, there are three key intersecting characteristics so far as class is concerned. Wide coverage covers discrimination by employers, widely defined, and by public authorities. Wide concept, or ought to be understood to be wide concepts of discrimination. So direct discrimination is defined as treating a person less favourably because of a protected characteristic, race, sex, as the case may be. A very simple idea, one would think, but very complex in practice, because in determining whether or not a person has been less favourably treated than another, one has to locate and identify the others. And it is often the very fact of the protected characteristic that means that people are not similarly situated. So saying, I want to have this job, you didn't give it to me because I'm black, can be answered with the simple answer: it's not because you're black, it's because you didn't undertake that unpaid internship, or you've worked in a different position, or you haven't had mentoring by blogs, whatever it is. So there is a difficulty with direct discrimination, even though it sounds simple. There is indirect discrimination, which is concerned much more with systemic inequality, so practices, policies and criteria that disadvantage particular protected groups are outlawed where they're not justified and where they fall within certain contexts, employment, discrimination by public authorities and so on. But again, a simple idea perhaps, but complex again because of the difficulty in identifying which groups we are concerned with in looking at relative disadvantage. And there have been problems with justification as well. So difficult concepts. There are equal pay provisions which offer greater protection because they don't require a comparator in the same way. One can compare oneself with a person who works in a different establishment, in a completely different job, where it's of different value, where it's of equal value, for example. But that only applies in the case of women. Very important, targeted at working class women, and has really provided positive outcomes, particularly in the public sector, where trade unions regrettably stitched up women during the 60s and 70s so that men got much better pay. That's been unravelled to a very great degree, but it doesn't cover other protected groups like black people and people from ethnic minorities who experience a very high pay penalty. So problematic, but there we have it. There are some positive measures under the Act. There is a duty on public authorities to have due regard to the need to achieve certain equality objectives, eliminate discrimination, promote equality, and foster good relations. There are obligations on public authorities to establish that they have met that duty by having due regard to the need to achieve those equality objectives, open brackets, just in parenthesis. They don't have to prove they have achieved them, they have to prove they had due regard to the need to achieve them. That's proved weaker than it might have been because public authorities have got used to producing, and you may well know this from your own professional backgrounds, producing very thin equality impact assessments and saying we had due regard to these matters, and regrettably courts being commonly persuaded by that. In relation to class, the only provision in the Equality Act that might be said to touch upon class specifically is Section 1 of the Equality Act, and this provides that certain bodies, ministers, government departments, local government, have to read this because I'll forget it, must, when making decisions of a strategic nature about how to exercise its functions, have due regard to the desirability of exercising them in a way that's designed to reduce the inequalities of outcome which result from socio-economic disadvantage. I have no idea what that means. What's desirability? I don't know. But in any case, we don't need to worry about it. The Act was passed in the wash-up period before the last election, and the coalition government didn't bring it into force. So we've got nothing to worry about in that department. As to the success of the Act, if the measure of the success of the Act, bearing in mind these are intersectional characteristics, intersecting often with poverty and class, if the measure is social mobility and economic security, then it's failed, and so has its predecessors, Race Relations Act, Sex Discrimination Act, Equal Pay Act, and so on. It's failed. I've already said something about social mobility. Additionally, in terms of pay, women from Black Caribbean and Black African backgrounds still more likely to experience significantly lower pay than even white women, and to experience severe material deprivation, changes to tax benefits, tax credits, universal credits since 2010 mean that by the 2021-22 tax year, the largest effects were felt by lower income, those in the lower income brackets, unsurprisingly, and women and people from certain minority ethnic groups. That position will, of course, and is worsening. Mostly those from minority groups and women, disproportionately at the threshold of the minimum wage. And I could go on, but there is, in addition to material, identifiable pay gaps and material disadvantage, there is also stigma. So women and black women in particular, black women in particular, women generally, but black women in particular, are more likely to be poverty shamed through the media as anti-welfare, as part of an anti-welfare rhetoric, with black women on benefits being characterised as welfare queens, guilty as claimants, racialised as criminal, and subject to greater surveillance, particularly where they're teenage mothers. And for the purposes of the discussion I'm having this evening, there is a very significant class gap. So even where one is in one of the higher level professions, law is one of the worst, even when one is in the higher level professions, there is still a very significant pay gap associated with working class origins. So I could go on about disadvantage, but I think that's a tiny sample. As to the other legal measures that might provide some support, and I'm looking here briefly at welfare benefits cases, and those are cases where the judiciary has demonstrated real hostility, and demonstrable hostility recently. And I'll come to that very briefly, not too much because of the audience. But Article 14, as you know, is what might be described as a parasitic right, where one can show that they are a right, a substantive right falling within the scope of the Human Rights Act is engaged, right to family and home life, for example. They can rely on the non-discrimination guarantee under Article 14, which prohibits discrimination, widely defined, direct and indirect discrimination, associated with race, sex, and so on, but also social origin, I emphasise, birth, and other status. Social origin being perhaps the key term for our purposes, or my purposes at the moment. Article 14 has been the route through which most of the welfare benefits cases have been argued, and that's because they plainly engage home and family life, either directly by the housing benefit cap, for example, or indeed the child cap, the number of two child cap. So as to the impact of the Human Rights Act, Article 14 in particular, and Article 8, it's been very problematic in the way that the courts have developed the concept of discrimination under Article 14. One of the earliest cases, not the earliest by any means in terms of welfare benefits, but one of the earliest cases where the court had to grapple with what forms of discrimination under Article 14 might be justified, because discrimination, whatever form it takes under Article 14, is capable of being justified by the state, had to grapple with what the concept of justification meant in the context of welfare benefits. And in the Humphreys case, in fact, it was a man, unusually, bringing a discrimination case under Article 14 in relation to the distribution between the mother and the father certain child tax credits. But in relation to that discrimination, sex discrimination, the court had to ask itself, what was the test? What was the threshold for justification? The importance of that is, ordinarily, where one of the suspect classes are engaged, and they are race, sex, disability, others too, but let's pick those for the moment, race, class, disability, suspect classes, the European Court of Human Rights have said the justification is set at a high level. Very weighty reasons must be established if such forms of discrimination are to be justified. In Humphreys, the Supreme Court said no, that's not the test in the context of welfare benefits. In the context of welfare benefits, the strict scrutiny test, the weighty reasons test, gives way to a manifestly without reasonable foundation test. So if the state can show that the discrimination or the discriminatory measure is not manifestly without reasonable foundation, it will establish justification, a very low threshold. To be fair to the Supreme Court, and I won't be in a moment, but to be fair to the Supreme Court, that was determined without any real dissent, regrettably, because it's now become dogma, without any real dissent from the parties. So there was no argument by the claimant that a different test applied, and that has now just followed through. So there are a number of welfare benefits cases. They're absolutely horrendous. I mean, they're people who are living in almost absolute poverty. Not quite, it's fair to say, within the meaning of that expression under the UN various documents, but sometimes almost absolute poverty. So the benefit cap, housing benefit cap case, as it says, housing benefit capped, wherever you live, whatever your circumstances, subject to a very small cohort that fell outside the Supreme Court's ruling, benefit cap lawful. Bedroom tax, that's a housing benefit cap. Bedroom tax, how many bedrooms can you have? If you have more, than the state considers necessary, even if you can't find another place, subject to a small cohort carved out by the Supreme Court, your housing benefit is capped. So it's capped at a particular level and then capped on the basis of how many bedrooms the state thinks you need, whether or not you have access to safe alternative accommodation or indeed accommodation elsewhere at all. And then the revised benefit cap, making it even worse. Again, all of these the Supreme Court found not manifestly without reasonable foundation, although they disadvantaged women in particular, unsurprisingly. Discriminated against women, sometimes disabled people, nevertheless, not discrimination because those measures were not manifestly without reasonable foundation. There are others. I won't go through them, but most recently, and this is the one where it seems to me the court is really demonstrating hostility, I should say, and not because Baroness Hale is here. I promise I'm not a judicial groveller, but it does seem to me, arguably, in fact, I'd go further than arguably and say most certainly, it seems to me that one of the motivations or one of the explanations behind the degree of hostility presently shown is the fact that we don't have Baroness Hale and Lord Kerr, who's very, very sadly passed and very much missed. We don't have them on the Supreme Court anymore, not because they were about to start a socialist revolution, I never got any sense of that, but because they did have some degree of empathy about ordinary people's lives. But in SC, new case SC, decided by the Supreme Court, Lord Reid, the new president, commented adversely upon discrimination cases being brought under Article 14 at all, censoring lawyers acting for NGOs, sometimes I should say for nothing or at very low rates, bringing cases in reliance on Article 14, where what's at issue, he takes the view, and the court took the view, were really political choices. Now, one thing to pick up here is that political choices are made by a court where the subject is the product of a political choice. Neutrality by a court is no less a political choice than intervention. Where one sees the public interest as reflecting one's own public interest and status quo, then that is as much a political decision and judgment as intervening. So very problematic, and Article 14 hasn't helped very much. So where could we see a model for class discrimination? Well, we see some model in Article 14 and the concept of social origin. That concept or that description, social origin, is found as well in the main UN human rights instruments, International Covenant on the Protection of Civil and Political Rights, and the International Covenant on Economic and Social Rights. Essentially the same group of characteristics, but very little said by the UN, as Van Buren in her excellent work tells us, very little observation made. But there is a place where there has been a lot of comment about the meaning of social origin, and where the UK is having a bit of trouble at the moment. The International Labour Organisation, the only tripartite UN institution, again has social origin within its concept of discrimination under its discrimination convention, and the committee of experts that has some responsibility for supervising that convention has decided that the concept of social origin includes class. And they have sent a very clear message to the UK that they ought to be amending the position, that is, the class isn't protected, and they have expressed regret at the absence of provision in relation to class, and regret for a UN body is really serious. So we're seeing now some movement. The UN governing the standards bodies are also looking at introducing some discussion about that at its central bodies. So class is a possibility through the concept of social origin, could be added as a protected characteristic, could be defined by reference to the collective or the collection of characteristics I've already defined. But finally, can we trust our judges to make any sense of it? So very briefly, just in a few more minutes, we know that 71% of senior judges went to private school, against a background of 7% more in the population more broadly. 23%, so most of the rest of them, went to grammar school. 75% went to Oxbridge, and they are the group after finance, so the second group who have the most advantaged educational backgrounds. Might be said that it doesn't matter, but increasingly scholars are saying that it does, not just in relation to gender, and the judicial identity blackout, as Barnes and Mallison describe it, is important. They draw on the work of John Griffiths, who, if you were an undergraduate in the 1980s and 1990s, was compulsory reading, and he makes clear that the fact that the judiciary as a group is dominated by a particular class matters because it informs concepts like public interest and where the line between politics and judging and law is drawn. So it's not just the individual bringing experience, the woman on a collective court bringing some valuable experience, or an ethnic minority being able to give some guidance to a court, but the whole of the judiciary, the collective matters because collectively it informs the outcomes of decisions where policy and public interest are engaged, and where judges very often, regrettably, identify public and political interest as aligning with their own, not intentionally, not deliberately, not, of course, in any sense improperly, but because they are a collective and they see their interests through the prism of that collective.
Gosh, what a lecture. Maybe we can close where we began. So the Provost spoke about our successes as a faculty in relation to the research excellence framework. And what we like to think is that we did well because of what we term intellectual generosity. So as a faculty, we're interested in doctrinal work, socio-legal work, historical work, empirical work, etc. And what we've seen tonight somehow is Karon able to do all of those things in one single 40-minute talk, which is really phenomenal. We had Bourdieu and Goffman, institutional logics. We moved on to a rich doctrinal analysis and a bit of judicial ideology. So I am wowed, I think, by what you've done tonight, Karon. So many congratulations on behalf of the UCL Laws faculty.